Great reporting as always, Anthony. You can go to lawandcrime.com to learn a little bit more of those stories. But right now, I want to focus on that last story right now with our special guest for the morning, juvenile judge and trial attorney Ashley Willcott. Ashley, welcome back to the program.
Good morning, Jesse. Thank you.
So as Anthony was saying, this guy, Jordan Hunt, has been charged in connection with two separate incidents, the one that you just saw and then another kind of assault. Obviously, we're talking about Canadian law, a little bit different. But what do you think he's facing here, realistically?
I think realistically, I suspect he won't face jail time. But, you know, it's so frustrating. It's like in any of the cases where you have freedom of speech. That's all well and good. But what you don't get to do is assault someone. He says his defense is, oh, I was just trying to kick her cell phone. I wasn't trying to kick her. I don't think that defense is going to fly, but I don't think he's going to face jail time.
Well, that's interesting because I don't know exactly what Canadian law is, but if he didn't intend to hurt her and was aiming for the phone and missed, is there any way that that might work?
Well, you know, I think there's an argument to be made that even though he was aiming for the cell phone and missed, it still could be fit within the definition, even in Canadian law, of assault, because, you know, kicking the cell phone could be connected to the hand could still be assault. So I don't think it's going to fly, but it might. I'm sure that's his defense. That's what he's saying the situation was.
It seems so ironic, right? He's trying to fight for women's rights, and yet he kicks a woman.
Yeah, they said misguided. I think misguided is being very gentle, right? He's committing a crime, and it is ironic, and I don't mean to be smiling, it's not funny, but it's like, you know, are you kidding me? This is his action to try to say I'm pro-choice. It just doesn't fly.
You know, abortion has always been a huge issue for years, but, you know, in today's day and age, maybe the conversation is heating up even more, especially with the discussion about Justice Kavanaugh. It became a big point of concern here in the United States. Are you concerned that these kinds of incidents, these levels of violence are going to increase as the conversation continues?
Absolutely, because I think, unfortunately, we often see in our country when there are extreme opinions and it gets heated in the political arena, that people become more extreme, and that extreme action can lead to these kinds of actions. So I do fear that, and I do think that this is escalating given all of the societal situations we find ourselves in right now.
Well, I hope you're wrong, and I hope that this is the end of the violence of Jordan Hunt, but we'll let our viewers know what ultimately happens to him when we get an update. So, you know, we'll talk more about that. Ashley, stand by, because we're going to switch gears ourselves. We're going to talk now again about the Brad Fields case. Again, we believe his sentencing will be at around 9:30 Eastern Standard Time, and we're going to report back about what his ultimate sentence will be. We'll talk about that. But as we recap some of that case, let's play the testimony of Cynthia Diaz, who is the grandmother of 4-year-old Gabby Barrett, and she'll talk a little bit more about this young girl and what ultimately happened. Chilling. The reason we are playing this is because today at around 9:30 Eastern Standard Time, we expect to see the sentencing hearing for Brad Fields, the man who was found guilty in connection with the death of this 4-year-old girl. He was found guilty of felony murder, second-degree child abuse, and torture. Back here with Ashley Willcott. Ashley, what could his sentence ultimately be for this horrific, horrific crime?
Yeah, so in this state, they don't have the death penalty, so we're not looking at that. But he could spend, I'd like to say, Jesse, I don't want to misquote. I need to look it up. I think it's as many as 75 years in jail. So I need to look up, and you may know that exact number. But he's looking at many years in jail potentially with this sentence, which, quite frankly, given the conviction, the horrificness of the crime, I think is hopeful that he does.
What kind of mitigating factors, realistically, could his team put on? I mean, this is a guy who was just convicted of brutally torturing and killing a 4-year-old girl. What are they going to put on? That he's nice to people at Costco? I mean, I'm not really sure. What are they really, can they realistically put on to sway the sentencing one way or another?
I think that his argument for mitigating factors is going to be, look, the mother did it. I'm not the mother. It's the mother's child. She did it, or she encouraged it, or I was there. And
won't that not work? Won't that not work because they already found him guilty?
Right. That's exactly the argument. But I think they're going to try to argue his state of mind as a mitigating factor and what he was going through in the home and what his personality was like in relation to the mother. I'm not saying it'll be successful, but I think they're going to argue that.
Now, the judge, we saw a little bit of it in this case. She really got vocal. She asked questions of witnesses. Did you find that a little strange that she took such a driver's seat?
Here's what's interesting. I deal, as you know, as a juvenile court judge with child abuse and neglect cases every day I'm on the bench. And I, frankly, ask a lot of questions as well. And so I think it is the discretion of the judge. I think it's the personality of the judge. And if they need that additional information or feel that the jury needs that additional information, it's not that unusual, at least here in Georgia.
Okay, well, we will have to see. Now, it should be noted we are playing some key moments from this case in anticipation of this sentencing hearing. And when we come back from our short break, we're going to talk more about the discussion between him and the young girl's mother. Stay tuned. Wow. Okay, Ashley, let's talk about those messages. Do you think that's really what sealed the deal for the jury and said, we don't buy for 1 second that it was just the mother who was responsible? And she's going to be facing her own trial later on, but that it's just the mother who's responsible here.
Absolutely, Jesse. I think that was the evidence that said he was connected, he was aware, he was involved. And in fact, on some of those text messages that you just heard testimony on, he was the one saying to her, do this, do that, put the child in a cold bath, all these different ways of punishing and abusing this child.
We unfortunately see these cases constantly, and we see a lot of times the justification by the parents or the guardians is that we were trying to discipline the child. I'm sorry, Ashley, you might see this more, but what is the rationale? Like, I don't understand what goes through someone's mind when they do this. How do they really justify this behavior? Because we're looking at an innocent 4-year-old girl, and we played the video in the courtroom where she's crying out. How do people do this?
Yeah, I don't think it can be justified. I don't believe they think, the perpetrators think that it's justified. There are lots of studies, right, and lots of statistics about how it happens, why it happens. To me, it's a sadistic crime. That's it. But there is some research about the fact some of these individuals are ignorant as to what's appropriate discipline because it was done to them as children. And so the trauma that a child goes through, if it goes untreated and lack of education and lack of good parenting and exposure, sometimes they become the perpetrator. It does not justify any of it, but we do see that by some of the studies that exist.
It's just unimaginable to think about what this young girl physically and emotionally went through. It's pretty awful. But I want to play the testimony right now of Deborah Lorraine, who is the victim's teacher. She is Gabby's teacher, and she's going to talk about, did she notice anything on Gabby, any bruises, anything like that? Because we seem to see this was a pattern of abuse. Let's find out. Okay, let's break this down with Ashley Willcott. Ashley, we're talking about Gabby Barrett, this 4-year-old girl who sustained multiple traumatic injuries and ultimately died from them. Brad Fields, one of her guardians, was found guilty of her murder, and now in a little bit he's going to face his sentencing. The question I have as we listen to this teacher is, a lot of times when you see these cases, do you see people who say, hey, I should have done more, I knew, I should have stepped in, I saw there was a problem?
Way too often, Jesse. And so often people don't report or don't do more because they're afraid, because they think, oh, maybe it didn't happen. They believe the parent. They don't want to get involved. Not wanting to get involved is a huge reason people don't do more. And remember, they're mandated reporters to report it to the state agency for child welfare. And everyone who thinks a child's being abused should report it.
Especially the teachers, because they get to see these kids more often than not.
And they are mandated reporters, so they absolutely should report it. Now, there are a lot of frustration with state systems and systemic issues, but it doesn't mean you don't report it.
Absolutely. Now, okay, we're going to talk more about Fields a little bit later on when we come back from our break. We're going to focus on the Roy Oliver case. But before we talk about that, we have an update for you here on Law and Crime. We are going to be live today in a brand new case that we haven't talked about. It is the Tammy Moorer trial. This is a woman who is on trial for kidnapping and conspiracy to kidnap a young woman named Heather Elvis, who disappeared and whose body has never been found. Now, Ms. Moorer was initially charged with kidnapping and murder charges, but those murder charges were dropped. It is believed that her husband, Sidney Moorer, will be called to testify in this trial. I know a lot of people are following it and are following the news on it, and we are going to cover it here on Law and Crime. So, busy day, ladies and gentlemen. We're going to take a quick break. When we come back, there's a lot to discuss. Stay tuned. Okay, let's bring in our very special guest to talk about what we've been seeing so far. Juvenile judge and trial attorney Ashley Willcott is back with us. Ashley, it's good to see you again. I don't know what I was doing without you.
Well, thank you. I'm sorry I'd lost you. My bad.
That's okay. That's okay. So what I've been talking about is how this case is eerily similar to the Jason Van Dyke, Laquan Edwards shooting. I mean, you have two white officers who gunned down two young African-American males. What do you see the differences and the similarities between these two cases?
So I think the differences for me go specifically to training of law enforcement officers, at least in the other case, and it doesn't justify it, but the individual was walking, had a knife in his hand. Granted, the video showed he was walking the other direction. In this case, you have a car full of people driving away. So is there any training? Is there any reason when a law enforcement officer should or could possibly perceive it to be a threat when a car is driving away? I would submit the answer is no, that is never a time when an officer can use force. And so to me, that it's a fine distinction, a fine line, but I think that can be the distinction between the two.
So, yeah, in Jason Van Dyke, he was studying the behavior of the assailant, you know, the victim in that case. If you want to say he was studying what's the behavior of the person holding the knife. We've seen countless testimony about that. This one's a little strange because what is he observing? He's observing the behavior of his partner to determine if there's a risk. Does that seem reasonable? Again, I mean, if he didn't know, he heard a shooting, heard gunfire, didn't know where the active shooter was, is it appropriate to respond to the behavior of your partner?
To me, that doesn't even sound possible. It doesn't sound reasonable. It sounds like something he made up to try to not get in trouble, right? Because I don't think it makes sense for an officer to say, well, I responded because of how I was perceiving my partner in this particular case. It just doesn't make sense to me, Jesse. So I don't think it is reasonable, especially, and the caveat for me here is the individuals were in a car driving away. So that in conjunction with even what you think your partner perceives, to me, should never be grounds to use the force that he used.
I got to ask you the million-dollar question. We got to go inside his head right here. When he said immediately after firing his weapon, oh, he was trying to hit you, do you think he really believed that, or was he trying to cover his tracks?
Based on the video, right, and there are different perspectives, so that doesn't show us everything. Based on the video, I think he just said that because he panicked, he shot, and was like, oh, crap, look what I did. That's what I think.
We've seen answers on both sides. I was just curious to get your perspective on that. Now, Ashley, stand by. We're going to play some other testimony that maybe our viewers haven't seen. This is Jeremy Seaton. This is another witness who saw the shots. It does get emotional. Let's play that testimony right now. Okay, so my correction, that witness was talking about the actual shooting, the one that happened before the Roy Oliver shooting. This is about those gunshots that were fired. Nothing to do with Jordan Edwards or any of his friends or brothers. It was about this other individual. That's who he saw. Now, I'm back here with Ashley Willcott. One of the things about this case is we do have an officer who was on trial. Now, I'm not going to reveal the verdict just yet, but the idea of that there was an active shooting situation, it wasn't as if the officer just came out of nowhere and shot someone. The idea that there was a chaotic nature to it, that cars were being stopped and that a car was speeding away. Does the jury look at that and say, well, wait a second, let's really think about this. Are we going to convict an officer who was maybe trying to do the right thing?
Well, I do think they look at all of the circumstances, and there's video that's been played or will be played, and that video is exactly of what you just described, the chaotic nature at the door and shots being fired and the police responding. So I don't think there's any doubt that there was a lot of chaos, that it was confusing. I can't imagine sorting through all of that with the loud noises, gunshot and safety threats as a law enforcement officer. So I think the jury's going to consider that. But I also think that they have to consider that in conjunction with the actual video and evidence regarding who was in the car driving away and what the partner testified to that he did not feel or perceive a threat.
Necessarily protecting himself. He claims he was trying to protect his partner. One of the things that we learned about from Mr. Oliver when he took the stand was his military background. And one of the things that he talked about was that he had a specific job in one of his tours was to protect a high-ranking member of the military at one point. That was his only job, to get that guy home safe. So if the jurors hear that and think that's what his background is, they say, well, that's interesting. It's not like he was trying to protect himself. He was trying to protect somebody else.
But does that protecting of someone else allow him in this case to use the force that he used to shoot into a car full of people? I think the argument by prosecution clearly is no. That's great. That was his training, and maybe he is trying to protect his partner. But does that mean that he had the reasonable perception of a threat to use the force that he used? And I think the answer of that is likely no.
Either way, and again, we're not telling what the verdict is, but when we have these kinds of cases, it's so important to hold these kind of officers accountable for when they use their weapons, right? We can't just have a situation where they pull the trigger and we say, well, they're justified.
Right, absolutely. And I think in this case, part of what's so important is he's saying I was protecting my partner. And the question becomes, in doing so, was it necessary? Was it reasonable that he fired his weapon? And that's the question the jury has to decide.
And we will let our viewers know, who don't know the verdict in this case, what they ultimately decided. But when we come back, we're going to play the testimony of Maxwell Everett, who was a friend of the victim and had a firsthand account and witness of the shooting. We'll be right back. Okay, welcome back, everybody. Let's dissect the last two pieces of testimony that we just saw from these two individuals that were friends with Jordan Edwards and were in the car with him when the shooting happened. I'm back here with Ashley Willcott to talk more about it. Now, you always talk about, Ashley, we always talk about the credibility of witnesses, right? Here you have young kids that were in the car. They see their friend gunned down. There's no dispute that he's dead. There's no dispute about who pulled the trigger. So if a jury's sitting there, do they have any reason, these two guys, to not be truthful, to not be credible about what happened?
Not when you have two individuals who are actually in the car. And Maximus, to me especially, boy, talk about those emotional heartstrings. They both, to me, were very credible witnesses. They were just answering the questions, describing what they saw, describing what they heard. They were there. And so I think that's very compelling evidence.
Now, we've seen every case we cover. You have different sides on each issue. There has been talk, there's been criticism that if you keep trying these officers for shootings, in a way it's going to restrict the behavior of officers, that it's going to put a limit on them when they decide to use deadly force, and maybe they'll be too late in situations because they're afraid of the repercussions. What do you say to that argument?
Well, here's what I think is really important to think about, and that is I do not believe that Roy Oliver woke up and went to work and said, I'm going to use deadly force and kill someone today. I don't think that he shot at the car and said, I'm going to kill someone. I don't think that's the thought process. The deadly force, regrettably, in our world is necessary for them to be able to use in the right circumstances to protect themselves and protect the rest of us. It's that line of when can they not use deadly force? And I think today's world, in terms of the pressures and the stresses and all of the chaos and behaviors, means that they're crossing that line and using deadly force sometimes when they shouldn't, and it results in a crime. But those are outliers, Jesse. We hear about it in the news a lot, but I still believe those to be outliers, and I believe that the majority of trained law enforcement only uses deadly force when necessary and appropriate.
So it's not an issue in terms of they're not trained extensively enough. There's a problem with each of these individuals. There's a problem with them. And maybe the question is, why were they led on the force in the first place?
That may be the question, and I think that's individualized to each group of law enforcement, whether it's city police department, whether it's a state police organization. That's where we have to look for each to make sure all of those training requirements are being met, that they are well trained, that they're doing the right background checks, that these are individuals that really have the capacity to serve and protect correctly.
But if you're a young kid in Chicago, or you're a young kid in Texas, or anywhere across the nation, and you're an African American, what do you do? You endanger. I mean, again, you have two situations where they're different, but what do you do moving forward? How do you protect yourself if there's an incident where police arrive? I mean, what do you tell these kids across America?
I don't know. I mean, that is part of the problem. But I am going to suggest this. Running is never a good idea because it seems like when they're running, whether in a car or physically, they still unfortunately ended up in these horrific circumstances. So I do think the answer is not fleeing because it seems like those go sideways sometimes.
Right. It's scary because anytime that they go out in a public place and you hear there was a party, there's a danger here that they're mistaken for something. It's a really scary situation. At the other hand, it's, how do we move forward from this? I guess it's a good thing that these officers are brought on trial because it's showing that there are repercussions if you break the rules, if you don't follow the mandates of force, of excessive force.
I think it's a necessary thing because that's our justice system. If they don't follow the mandates of the force, deadly force, and when it can be used, it does result in a crime. And so it's a hard balance. I don't know what to tell these kids.
Ashley, we will talk more about this right after this break, so everyone stay tuned here on Law and Crime. Thank you, Anthony. Great reporting as always. And you can go to lawandcrime.com to follow those stories, including the one that I had just talked about earlier with our very own Ashley Willcott about that Jordan Hunt character. Now, Ashley, I know we have to sign you off, but thank you so much for your discussion about that case as well as the other cases that we've covered today.
Thank you, Jesse. Have a great one.
You too. All right, everybody. We're going to switch gears right now, and we're going to go back to talking about Roy Oliver.